Leader.
Mr. Deputy Speaker, may I seek your consent and the general assent of members present to move that the proceedings on item number 1 in the order paper for today be exempted from the provisions of Standing Order number 48.3 so far as it is necessary to enable Minister of State for Ministry of Home Affairs and Ministry of Social and Family Development, Xueling, and Senior Parliamentary Secretary, Ministry of Health and Ministry of Law, Ms. Rahayu Mahzam, to speak more than once. In the course of the debate, MPs have directed queries to both SPS Rahayu and MOS Xueling, who had spoken on behalf of MINLAW and MSF, respectively. I wish to move this motion so that MOS Sun and SPS Rahayu can respond to members' queries on the specific elements of the bill and related matters.
I give my consent. Does the Leader of the House have the general assent of honourable members present to so move? Aye. Leader of the House, please proceed.
Mr. Deputy Speaker, I beg to move that notwithstanding the standing orders, the proceedings on item number 1 in the order paper for today be exempted from the provisions of Standing Order number 48.3 in respect of MOS Xueling and SPS Rahayu Mahzam speaking more than once.
The question is as moved by the Leader of the House. As many as are of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. SPS Rahayu Mahzam.
Sir, I thank members for their comments and expressing support for the bill. I will address the points raised in relation to the new Maintenance Enforcement Process, MEP, and the enhancement of court proceedings and procedures in the FJC. I will start with the members' questions on the scope of the new MEP. Mr. Zulkarnain hopes that the MEP will apply to the enforcement of Sharia court orders. The MEP will indeed apply to orders made by the Sharia court, which under the Administration of Muslim Law Act may be treated as maintenance orders made by the family court for the purposes of enforcement. Mr. Zulkarnain also asked about past outstanding maintenance and limitation periods. The bill does not change the existing position on limitation. Generally, an applicant needs to commence proceedings to enforce arrears within 3 years from the time that such arrears are due. The applicant will then be able to include those arrears in future enforcement applications if the arrears remain unpaid. If the applicant acts in a timely manner, the respondent cannot circumvent his or her obligations. On past maintenance arrears, the MEP will, when fully implemented, apply to all maintenance enforcement applications. Mr. Murali Pillay has asked about MEOs being cited under the executive. The new MEOs will gather evidence and carry out conciliation to help parties reach a sustainable solution. However, if parties do not settle, the court will still make a final decision, possibly using information and evidence gathered by the MEO. It is therefore preferable for the MEO's evidence gathering and conciliation roles to be independent of the court. We have discussed this with the judiciary, which supported a proposal for the MEOs to be cited within the executive. AGC's advice was also sought on the matter. Mr. Louis Ng asked who we intend to prescribe as the third parties from whom MEOs may seek information. In Minister Shanmugam's opening speech, he listed them, the Central Depository Private Limited, and the government agencies such as CPF Board, HDB, IRAS, SLA, and LTA. Mr. Melvin Yong asked about information on foreign assets. The bill does not have extraterritorial effect. The MEOs and the Singapore courts do not have powers to direct third parties in a foreign jurisdiction to provide information. Mr. Ng also asked about the contemplated timelines to disclose information sought. We have been engaging the banks and third parties that we intend to prescribe, and we will work with them to implement the MEP, which would include response timelines. Mr. Murali Pillay also raised the concern that assets may be held in the name of proxies. Mr. Pillay also requested for clarification on the ambit of a third party under the bill and whether a third party may be asked to disclose information relating to proxies. The third party may be any person who has relevant information. Thus, if an MEO in the course of fact-finding has reason to suspect that the respondent has assets that are held in the name of proxies, the MEO may seek a court order for a third party to disclose information about the assets. It is for the court to decide if such information is relevant to the enforcement application. There are limits to the MEO's powers to uncover every fact. It is ultimately the primary responsibility of the parties to be forthright about their true financial positions. Furnishing false information when asked by an MEO or to the court is a criminal offence. Mr. Ng asked about the number of conciliation sessions and the consequences for failing to attend or not participating in good faith. The bill does not impose a limit on the number of conciliation sessions. We envisage that there will typically be 2 sessions, but the exact number will vary. It is the court that directs the parties to attend conciliation. Failure to attend is therefore contempt of court. Further, if the respondent is absent from conciliation, the court may direct the respondent to attend another conciliation session. The court may also proceed with the hearing of the application. If the respondent is absent for the hearing of the application, the new family justice rules will allow the court to proceed to make the appropriate orders if certain conditions are satisfied. This should also address Ms. Ng Ling Ling's question about her resident whose application got stuck because the ex-husband could not be found. With respect to parties who do not participate in good faith, the parties' conduct during conciliation will be set out in the MEO's report to the court. The court may take the parties' conduct into account in making the appropriate orders on the maintenance enforcement application. Mr. Ng asked whether the matter will still proceed to hearing after the MEO refers parties for financial assistance. Financial assistance is not intended to replace the parties' financial responsibilities to their families, but acts as a safety net for our fellow Singaporeans in need. The matter will therefore still proceed for conciliation and hearing after the MEO makes the referral to financial assistance. The MEO will take into account the financial assistance granted, if any, as part of the overall assessment of the financial circumstances of the parties. The court will also take into consideration information on any financial assistance granted in deciding on the appropriate orders to be made. Mr. Yong asked about whether it is an offence for a respondent to refuse financial assistance despite an MEO's referral. The answer is no. It is open to a respondent to decide whether to accept financial assistance. I will turn to Mr. Ng's and Mr. Dennis Tan's queries on what the MEO's report will set out and whether the reports will be provided to both parties. The MEO's final report will be provided to both parties and submitted to the court. It will contain all the information submitted to the MEO in relation to the maintenance enforcement application, matters relating to conciliation sessions, and any other matters and information as may be prescribed. In respect of interim reports, the clause which Mr. Dennis Tan referred to allows the MEO to provide an interim report to the applicant only first to cater for a situation where the MEO needs to inform the applicant of an impending dissipation of assets so that appropriate action can be taken. The intent is for the interim report to eventually be available to both parties in accordance with the rules. The intention is for the MEO to provide all relevant facts and evidence for the court's consideration. The court may then, if it thinks fit, rely on the MEO's report to make the appropriate orders against the respondent's assets without calling for further evidence. We may prescribe additional matters to be covered in the report as we learn from the initial phases of implementation. Mr. Dennis Tan has also asked what information may be redacted from the MEO's report. The MEO has broad powers to gather information for the court from third parties, including information that is ordinarily private and confidential. The MEO reports this to the court. There may be information gathered by the MEO and in the report that is unnecessary or irrelevant. This power will allow for such information to be redacted to protect the parties' interests. Mr. Ng and Mr. Yong also asked whether there is a standard rubric for MEOs to assess the parties' financial position. Mr. Gan Thiam Poh referred to challenges with distinguishing between those who will not pay and cannot pay cases. Both Mr. Gan and Mr. Lim Biao Chuan cited examples of respondents who have the ability to earn an income or better income but chose not to do so. There is no fixed formula to determine whether a respondent has the means to pay maintenance. Each case will be assessed on its facts, based on information on the parties' assets and means. That being said, the MEOs will be trained and given guidelines on making these assessments. We will work closely with social service officers from MSF to develop these guidelines. Ultimately, it is for the court to decide whether the respondent cannot pay or refuses to pay and the appropriate orders to make. The court will consider the MEO's report in coming to its decision. The FJC judges are trained to deal with a wide range of family situations and also have the powers to make orders to address the unique needs of each family. They will also be supported by counsellors and other professionals who will be able to provide therapeutic interventions. For example, if a respondent is retrenched and has challenges paying maintenance due to the sudden loss of income, the court may suspend the maintenance order or vary the maintenance amount downwards for a short period of time and make the appropriate directions for the respondent to report back to the court on a specified date after he or she has had time to look for a new job. The court may also make an order requiring the respondent to undergo financial counselling with the professional counsellor, who will be able to help the respondent explore various options to manage his or her daily expenses and to pay maintenance. Mr. Gan also suggested that the MEOs may also assist the court at the stage of division of matrimonial assets. We thank Mr. Gan for his suggestion, which we will study. Mr. Zulkarnain, Mr. Ng, Mr. Yong, Dr. Wan Rizal, and Ms. Henny So have asked about MEO's recruitment, training, and resourcing. These are operational details that will be worked through in implementation. Suffice to say that we intend to hire and train a multidisciplinary team, with team members having or being trained and equipped with knowledge and skills in different areas. This will include the skills needed to effectively manage the parties in family proceedings. We also thank Ms. So for her suggestion on taking a coordinated approach across the entire family justice ecosystem. We will certainly keep this in mind as we develop the training programs in a way that strengthens therapeutic justice outcomes. Mr. Zulkarnain had asked about legal protections for the MEOs. The bill gives the MEOs protection against personal liability when they exercise their powers or perform their functions or duties, provided they do so in good faith and with reasonable care. I will now address the questions and comments that members have raised with respect to the powers of the court hearing the maintenance enforcement application. First, on the court's powers to vary the maintenance orders. Mr. Ng expressed concern that potential for variation may disincentivize some applicants from applying for enforcement. Mr. Lim also asked about variation where the respondent loses his or her job or if he or she has a new family. The MEP does not change the substantive law in relation to variation of maintenance orders. The test that the respondent has to satisfy remains the same. What the MEP does is to reduce the procedural challenges that parties face in seeking variation. For example, the court may vary a maintenance order made during matrimonial proceedings only when it is satisfied that the order was based on any misrepresentation or mistake of fact, or where there has been any material change in circumstances. The court will consider all relevant facts and circumstances before deciding whether there has been any change in circumstances warranting a variation of the maintenance order. New financial commitments and loss of job could be relevant considerations. However, the courts have held that remarriage per se does not affect pre-existing obligations owed to the family from an earlier marriage. Similarly, when MEOs make recommendations to parties to facilitate an out-of-court settlement, remarriage and loss of jobs are but two of the various factors that will be considered. Maintenance orders would not be varied in cases where the respondent has the means to pay the maintenance sum. In cases where the respondent has genuinely experienced a change in circumstances affecting his or her ability to pay maintenance, the MEP will help the court make a more accurate assessment of the nature of the change and accordingly make more accurate variation orders where needed. This can be a temporary variation to deal with a temporary change in circumstances, but it leads to a more sustainable outcome for all parties. On the other hand, if we turn a blind eye to the changed circumstances, respondents will continue to miss maintenance payments time and time again, even if multiple enforcement applications are made and concluded against them. Applicants will spend time and costs on enforcement only to end up being disappointed each time. It would be far better for such applicants to receive the appropriate financial assistance and other forms of support or enter into a more sustainable maintenance arrangement with the respondent. The new MEP facilitates this. Mr. Gan also asked about the circumstances in which a respondent would not be imprisoned or lower maintenance amounts ordered because of his or her medical conditions. These are decisions that ultimately for the court to make, taking into account all the circumstances of the case. Where there are disputes of fact, for example, on the medical conditions of the respondent, the MEO may help to gather the relevant facts and evidence, including seeking information from third parties to verify the parties' position. The court may also direct the MEOs to conduct further fact-finding if necessary. On attachment of earnings orders, Mr. Ng asked whether earnings from freelance or gig economy work are earnings that may be attached. Earnings for the purpose of attachment of earnings orders is defined in the new Section 76 of the Women's Charter to refer to wages or salary payable under a contract of service. Therefore, depending on the way the contractual relationship between the worker and the firm is structured, it may well be that in some cases such earnings may fall within the definition of earnings. Attachment of earnings orders work effectively where there is a regular and stable stream of income that can be directed towards the fulfillment of periodical maintenance payments. They do not work so well where the income is unpredictable, such as for freelancers and contract workers. Including such arrangements may lead to hardship for the parties and administrative challenges for the firms who engage these workers. Hence, attachment of earnings orders will generally not be made in respect of income from gig work, which is unstable. Where incomes are not stable, the family's financial situation is naturally more complicated, and it is not always easy to find simple solutions. The MEOs will help parties look at the overall picture and suggest arrangements that are sustainable. Ultimately, regardless of the type of work one does, the respondent must be responsible for fulfilling his or her obligations for maintenance. Even if the attachment of earnings order is not available, there are various other ways to hold them accountable. Mr. Lim and Mr. Dennis Tan said that respondents who delay paying maintenance to frustrate the complainant should not be allowed to walk away without consequences. The bill allows for consequences to be imposed on such respondents. For example, the court may imprison a respondent who has no good reason for failing to pay maintenance on time, even if that respondent pays up after the applicant files the enforcement application. Further, for a respondent who has not paid maintenance in a timely manner and the parties have not settled, the court must make a show payment order for the respondent to show proof of payment of any future maintenance payable. An imprisonment term may also be specified for the breach of the show payment order. Mr. Lim also asked about situations where the respondent refuses to pay because he or she is denied access to the child. Being denied access is not grounds for non-compliance with a maintenance order. A parent has a legal duty to maintain a child whether the child is in his or her custody or not. If the respondent is denied access to the child, he or she may take up an application for the enforcement of the access order. I will now address some of the other comments made or questions asked in relation to maintenance enforcement. Mr. Zulkarnain suggested that all maintenance orders be placed on a searchable database registry and that a recalcitrant defaulter can be placed on a blacklist with an alert to the Credit Service Bureau. The Women's Charter already provides for an applicant who has filed for maintenance enforcement to be able to lodge a report to a designated credit bureau regarding unpaid arrears stated on the order of court. Applicants will continue to be able to lodge such reports under the new MEP. Under the new MEP, the MEO may also assist to lodge the arrears report. This may be helpful for applicants who have challenges filing the arrears report on their own. Mr. Gan has also asked whether maintenance payments will be prioritized over other debts. Mr. Zulkarnain has asked for clarification on how the new MEP and the bankruptcy regime will interface with one another. As Mr. Zulkarnain has correctly mentioned, the reforms in this bill do not change the order of priorities of an insolvent debtor. The reforms also do not change how enforcement proceedings or orders ordinarily interact with the bankruptcy regime. Mr. Zulkarnain and Mr. Gan have also asked what can be done when respondents are declared bankrupt or respondents are struggling financially. Dr. Wan Rizal raised concerns of harshness on parties genuinely unable to pay. Mr. Zulkarnain mentioned that for bankrupt respondents, applicants are unlikely to be able to recover any arrears, but yet are saddled with the expenses of the children. This is where the reforms under the MEP may be helpful. The MEOs will be able to verify whether the respondent has genuine financial difficulties. This would include considering, like what Mr. Gan said, whether the respondent has genuine responsibilities paying for their children and elderly parents' expenses. Where the respondent has genuine financial difficulties, the MEOs, where appropriate, may refer the parties to social service officers for financial assistance or other forms of support. Ms. Ng Ling Ling and Mr. Zulkarnain ask if there can be more practical help for vulnerable individuals and laypersons applying to enforce their maintenance orders. The new process was designed specifically to reduce the burden on parties, especially self-represented persons, SRPs. Nonetheless, certain litigants may still require more help than others. Today, there are various physical touch points where such SRPs can seek help in filing a maintenance enforcement application, such as the Services SG Centres at our Tampines Hub and One Punggol, the Divorce Support Specialist Centres, the SSAs, and the Singapore Council of Women's Organisations. We will work with Service SG and MSF to ensure that such services continue to be offered even after the new maintenance enforcement process is implemented. Ms. Ng's suggestion to train social service officers and social workers to help their vulnerable clients navigate the online application process and make the appropriate referrals is a good one, which MSF will explore. We will work together with our partners and stakeholders in the legal and social service sectors to disseminate information on and raise awareness of the MEP. Mr. Zulkarnain reiterated his support for empowering judges to impose restrictions on cross-examination in prescribed circumstances. He also mentioned video conferencing facilities for young survivors to give evidence. As Mr. Zulkarnain noted, he would be glad to know that video conferencing facilities for victims of family violence are already available at the FGC today. The Family Court may permit the giving of evidence through a live video or live television link in family violence proceedings under the Women's Charter where certain conditions are satisfied, including where the witness is below the age of 18 years old. The court will assess the relevant facts and circumstances of each case to decide if such permission should be given. This includes the suitability of the witness to give evidence via live video or live television link and the nature of the evidence that the witness will be giving. Apart from arranging for such witnesses to give evidence by video in a separate room in the FJC, the court may also permit a vulnerable witness to be accompanied by a trained court volunteer recruited by the Singapore Children's Society under the Vulnerable Witness Support Program. The trained volunteer will not only accompany the vulnerable witness during the court proceedings, but will provide the witness with information about court process and procedures and continue to provide the witness with emotional support after the hearing. Mr. Pillay spoke about ensuring that the housing needs of divorcing parties and children are addressed when the court decides on the division of the matrimonial flat. The parties are required to provide key information on their HDB property as part of the divorce application. In deciding the division of the matrimonial assets, the court does consider the welfare and needs of the children. The court may also direct parties to seek HDB's views and consider information provided by HDB on, for example, the retention of the matrimonial flat and post-divorce housing options for the divorcing parties and their children. There are also various support schemes put in place by HDB and MSF to ensure a smooth housing transition for divorcees. To equip parties with the knowledge and skills to make informed decisions regarding the matrimonial property that prioritizes the child's well-being, MSF's Family Assist portal will provide parties with information on post-divorce housing options. The mandatory co-parenting program, which all divorcing parents with minor children must go through before filing for divorce, will equip and encourage parents to make informed decisions, including on post-divorce housing arrangements, which prioritize the well-being of their children. The court can refer divorcing parties to HDB for housing counselling before the divorce is finalised, for them to better understand their post-divorce housing options. In deciding the division of the matrimonial flat, even when the parties have reached an agreement, the court does consider the welfare and needs of the children and direct parties to seek HDB's views. The court may consider information provided by HDB on, for example, the retention of the matrimonial flat and post-divorce housing options for the divorcing parties and their children. Nevertheless, we thank Mr. Pillay for his suggestions, and we will continue to study how the process relating to the division of the matrimonial flat may be strengthened to protect the interests of the children. Ms. Henny So has asked about the docketing system for divorce proceedings on the ordinary track. She also made suggestions on how a global settlement could be facilitated. Whether a contested case is suitable for docketing to designated judges depends on the facts of the case. Generally, high conflict cases and cases involving highly contentious issues on the custody, care and control of children are docketed. As far as possible, docketing is done in the earlier stages of proceedings to allow a single judge to take charge of the case. Presently, almost all contested cases are referred to mediation in the early stages of proceedings. Nonetheless, we thank Ms. So for her suggestions and will certainly continue to study how we can improve therapeutic justice outcomes in all aspects of the divorce process. Mr. Lim Yao Chen has asked about allowing the FGR to prescribe that judges may conduct interviews with children. Mr. Louis Chua have also made suggestions on training family judges to handle children in interviews with them. I mentioned in my opening speech the rationale behind this amendment, including the need for more clarity in the legislation. I also briefly mentioned that judicial interviews are not the only, nor the preferred method of ascertaining a child's wishes, but will complement the variety of methods that can be used to hear the child's voice. I would add that family judges do receive specialized training on whether, when, and how to interview a child. This training sensitizes family judges to the needs of a child, the safety concerns, and the potential impact the court proceedings may have on the child. Judicial interviews of children may also be conducted in the joint presence of FJC's court family specialists who are proficient in interviewing children. The court family specialist is a trained professional and experienced counsellor, psychologist, or social worker from the Counselling and Psychological Services, CAPS, which is the social science arm of the Family Justice Courts. Mr. Yong asked about the minimum age of children being interviewed. There is no minimum age in legislation. As the ability to communicate can differ across children of the same age, a different approach may be required for each child. The courts have, however, held that judicial interviews would only be useful when the children are mature enough to convey their views independently. The Women's Charter also provides that the child should be of an age to express an independent opinion. Mr. Deputy Speaker, in Malay, please. Prosiding keluarga adalah unik. Ia juga seringkali melibatkan anak-anak yang paling teruk terjejas akibat hubungan yang tegang dan ikatan keluarga yang retak. Inilah sebabnya keadilan terapeutik atau therapeutic justice sangat diberi perhatian dalam melaksanakan prosiding keluarga. Kita mahu proses mahkamah mengajak keluarga ke arah penyelesaian yang membawa manfaat buat semua. Kita mahu melengkapkan keluarga-keluarga yang terlibat dengan alat-alat dan kemudahan yang diperlukan supaya mereka boleh maju dan pulih daripada kesempitan. Kita tidak mahu melihat keluarga terperangkap dalam litigasi yang sengit. Oleh itu, rang undang-undang ini bertujuan untuk mengukuhkan unsur-unsur keadilan terapeutik dalam sistem keadilan keluarga. Antara beberapa usul dalam rang undang-undang ini termasuk memperkukuh kuasa hakim dalam mengambil pendekatan proaktif terhadap kes-kes yang dibicarakan. Ini termasuk membenarkan mereka untuk membuat perintah tertentu menurut kebijaksanaan mereka sendiri bagi menangani keperluan mendesak keluarga yang terlibat. Memberi kuasa kepada hakim untuk tidak membenarkan pihak yang terlibat daripada mengemukakan permohonan lanjut yang tidak perlu dan tiada sebab yang kuat tanpa kebenaran mahkamah, dan membolehkan para hakim mengenakan sekatan ke atas pemeriksaan balas atau cross-examination dalam keadaan-keadaan tertentu jika soal siasat ke atas saksi yang lemah mungkin boleh menakutkan atau bersifat menindas. Reformasi baru ini akan melengkapkan beberapa peningkatan kepada sistem keadilan keluarga yang telah dilaksanakan oleh Kementerian Pembangunan Sosial dan Keluarga MSF dan Kementerian Undang-Undang MINGLAW bersama-sama dengan Mahkamah Keadilan Keluarga FJC sejak beberapa tahun lalu untuk menjadikan prosiding keluarga kurang sengit. Hari ini di Parlimen, rang undang-undang pembaruan keadilan keluarga akan memperkenalkan perubahan besar terhadap proses menguatkuasakan perintah pembayaran nafkah. Sepanjang beberapa tahun yang lalu, kami telah memperhalusi secara progresif rangka kerja penguatkuasaan perintah pembayaran nafkah. Walau bagaimanapun, kami masih melihat bilangan kes yang agak tinggi terhadap pihak yang tidak mematuhi perintah pembayaran nafkah. Kami telah menerima maklum balas mengenai kebimbangan, kekecewaan dan kesan-kesan kehidupan sebenar lain yang dialami oleh pemohon. Perubahan ini bertujuan untuk memenuhi keperluan maklum balas yang diterima. 1 unit baru pegawai penguatkuasaan bayaran nafkah akan ditubuhkan, MEU. Pihak-pihak tidak lagi perlu memohon ke mahkamah dan melalui proses undang-undang formal untuk mengumpul bukti mengenai aset dan kemampuan pihak-pihak terbabit. MEU akan diberikan kuasa untuk mendapatkan maklumat tersebut secara langsung daripada pihak-pihak terbabit atau daripada entiti yang ditetapkan seperti bank, lembaga tabung simpanan pekerja CPF, lembaga perumahan dan pembangunan HDB, IRAS, SLA, LTA dan CDP. MEU akan mengemukakan maklumat ini kepada mahkamah dan mahkamah boleh menggunakan maklumat ini apabila membuat keputusan. Proses penguatkuasaan pembayaran nafkah MEP akan ditetapkan untuk perintah mahkamah yang dikeluarkan oleh Mahkamah Syariah Singapura di bawah Akta Pentadbiran Undang-Undang Islam (AMLA) dan boleh dianggap sebagai perintah nafkah yang dibuat oleh Mahkamah Keadilan Keluarga bagi tujuan penguatkuasaan. Hasilnya, ini menjimatkan masa pihak-pihak kerana tidak perlu menghadiri pelbagai perbicaraan mahkamah, menjimatkan wang kerana tidak perlu membayar yuran guaman dan mengurangkan kesusahan kerana tidak perlu membuktikan aset dan kemampuan pihak terbabit. Diharapkan pembaharuan terbaru ini akan membantu mengukuhkan lagi sistem keadilan keluarga dengan mengurangkan rasa permusuhan, sakit hati dan derita keluarga serta anak-anak. Mr. Deputy Speaker, I will now conclude. The amendments in this bill will simplify and make family proceedings more efficient. They will also reduce acrimony in family proceedings, strengthening therapeutic justice in the family justice system. With the new MEP, strengthening deterrence against respondents who refuse to pay and facilitating more sustainable maintenance outcomes where respondents cannot pay, it is hoped that situations where children and vulnerable family members are left in financial neglect will be reduced. We will also continue to work closely with our partners in the legal community and social services, such as the DSSAs, to provide more avenues of support to individuals who may nevertheless find the process challenging. Where the financial needs of the families who have undergone a breakdown are met in a timely manner, this will go a long way to helping families to heal and move on from the breakdown of the family unit in a positive manner. Divorced parents will also be able to better focus on co-parenting in a manner which best protects their children's interests. Thank you.
MOS Xueling.
Sir, I thank members for the robust debate, the pertinent issues raised, and the support for the bill. I would like to begin by reiterating MSF's commitment to building strong families. Mr. Melvin Yong brought up the importance of strengthening marriages and families, thereby reducing the number of families who have to go through the painful process of divorce. Indeed, this is MSF's belief, and efforts have been put across all life stages through various government initiatives to support families through their life journey. Such efforts span supporting families in setting strong foundations in marriage and parenting, in the cost of raising their children, in navigating and overcoming difficulties, and in aging well. These are efforts that we continually build on, and proposals from members on how we can make further strides in this regard are always welcome. Members have expressed their concerns regarding a family's ability to move on financially post-divorce. Mr. Louis Ng asked about support provided to families early to sort out their finances when a marriage has broken down. In December 2021, the MSF launched the Family Assist portal, which supports couples contemplating divorce and provides them with information and services to make informed decisions in the best interests of their children. This includes information on the impact of divorce on finances and housing. A personalized tool will also be launched on the portal soon to help citizens better understand their post-divorce HDB options. Mr. Louis Ng also asked if financial counselling can be incorporated into the co-parenting program. Like I mentioned earlier in my opening speech, we have made it mandatory for all divorcing parents with minor children to go through the co-parenting program. And today, this co-parenting program covers practical issues arising from a divorce, including modules on making housing arrangements and managing finances. During the co-parenting program consultation sessions, counsellors may also refer parties to financial counselling services. Mr. Louis Chua asked about financial assistance for those referred to the SSOs under the maintenance enforcement process. Where possible, we will streamline the sharing of data between the maintenance enforcement process and the SSOs. The details will need to be worked out with the setup of the new unit. The details will need to be worked out with the setup of the new unit of MEOs. I would like to assure members that our SSO officers will assess the applicant's circumstances and needs holistically and assist them accordingly. This includes interim assistance for cases requiring urgent assistance, such as if maintenance is not being paid and has resulted in financial difficulties. It was heartening to hear from Ms. Yeo Wan Ling about the work that NTUC's Women and Family Unit is doing to support single mothers and divorcees. The MSF believes in the importance of caring for and supporting women in such vulnerable situations and had announced several efforts as part of the 2022 White Paper on Singapore Women's Development. This includes partnerships between the government and community partners under the Alliance for Action to Strengthen Marriages and Family Relationships. As an example, MSF's community partner, HCSA, has updated their portal, SPIN, which stands for Single Parents, Informed, Involved, Included, to address questions divorcees may have towards housing and childcare arrangements. The MSF is focused on ensuring that childcare arrangements do not exact a burden on single or divorced parents so that they are able to seek employment and provide for themselves and their family members. We welcome partnerships with NTUC Women and Family Unit to further enable single or divorced parents. Mr. Louis Chua had raised the issue of divorced parents being unable to come to an agreement on their child's education arrangements and their housing arrangements. We think it best for parents to work out suitable arrangements cooperatively and encourage them to do so outside of the court system, bearing in mind what would be their children's best interests. It is for this reason that we have made it mandatory for all divorcing couples with minor children to go through the co-parenting program. It is not ideal for parents to seek to rely on court orders to exhaustively list the decision rights for all matters pertaining to their children. On the issue of school arrangements, in particular, something as important as a school transfer, parents who have joint custody of their child need to come to a common agreement on the child's school transfer. I hope members can understand that schools have to be seen to be fair to both parents, and it is not ideal for divorced spouses to bring their differences to the school to be the arbiter. Our housing policies prioritize our limited public housing supply for households with the greatest need, such as those that involve children. As such, divorcees with children are a family nucleus and can apply for public housing. For divorcees without children, they can retain their matrimonial flat alone if they are at least 35 years old. If they are below 35 years old, they can retain their flat if they include a family member, such as either of their parents, to form an eligible family nucleus. The HDB does allow divorcees below age 35 without children to retain their matrimonial flat alone on a case-by-case basis. Mr. Leon Pereira had asked whether we would consider providing for maintenance for ex-husbands and men. This has been raised in several occasions by various MPs, including Ms. Carrie Tan and Mr. Ang Wei Neng. In 2016, we took a significant step to allow men to apply for maintenance if they were A, incapacitated before or during the course of the marriage, B, are unable to earn a livelihood, and C, are unable to support themselves. I will also add that the courts have also refrained from granting high amounts of maintenance to wives who are able to work, even if they had not worked or stopped working for some years. The court's goal is to award reasonable maintenance such that it will meet the financial needs of the wife until such time that she could secure for herself some form of employment and adjust to her post-divorce situation. I would like to state unequivocally that we fully appreciate the sacrifice that men make when they step away from their careers to become stay-home husbands and acknowledge their efforts towards their families. MSF will continue to study the issue and review if husbands and ex-husbands can apply for maintenance payments. Queries were also raised by members regarding support for family violence survivors. I will be introducing the Family Violence Amendment Bill tomorrow in this House, which will effect the key recommendations from the Task Force on Family Violence in tackling family violence. I would like to close by reiterating that we are committed to ensuring good outcomes for families and their children, even as we support families in navigating their divorce and adjusting to life post-divorce. The maintenance enforcement process is a big step towards ensuring that families are able to resolve issues surrounding maintenance that may arise post-divorce in an effective and non-acrimonious way. It is a key piece that we are adding to our comprehensive landscape of marriage and divorce support to give every family the best possible chance of achieving good outcomes despite the ups and downs in life. The MEP will take some time to be implemented as we want to ensure that the right persons are hired to play the key roles of maintenance enforcement officers and that the process is set up well. We are confident that when the maintenance enforcement process takes effect, it will make a meaningful difference in terms of ensuring sustainable maintenance payment outcomes for all parties involved. Thank you.
Minister for Law, Mr. K. Shanmugam.
Mr. Deputy Speaker, sir, thank you. My colleagues, SPS Rahayu and MOS San Xueling, have answered the points raised by members. I would just end by reiterating my thanks to the various stakeholders in the family justice ecosystem. And with that, sir, I beg to move.
And there are no clarifications. The question is that the bill be now read a second time. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. Committee stage what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of the opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 45 stand part of the bill. As many as are of the opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. Bill to be reported. The Minister for Law.
Mr. Deputy Speaker, sir, I beg to report that the bill has now been considered in committee and agreed to without amendment.
Third reading what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it.
Family Justice Reform Bill.